Hello, everyone, and welcome back to the summit. We're having a great time, and we're super excited to be able to share even more valuable information with you. And we have another amazing presenter for this masterclass, this session. We have Michelle Schaap. She is an attorney with the CSG law firm in New Jersey, and she specializes in data security and privacy. And she has a ton of experience, and we are super excited that she has taken the time today with us to speak on um, getting C-suite buy-in to your security and privacy programs and some other topics along that lines. Thank you, Michelle, for being with us today.
Thank you. We appreciate it.
My pleasure. Good morning, everybody, or good afternoon, depending on what time you're viewing this. My name is Michell Schaap. I'm with CSG, or Chiesa, Shahinian, and Giantomasi, but CSG is much easier. Although we are primarily in New Jersey, we also have offices in New York. And when it comes to data security and privacy, needless to say, internet has basically eliminated borders. And as a result, as an attorney practicing in this area, I keep up to date with laws literally across the country. And those laws are changing regularly. New laws are coming into play. Old laws are being amended, and of course, then you have the privilege of dealing with GDPR, the General Data Protection Regulation, and other outside the U.S. regulations to the extent that you have businesses that are operating internationally. And before I pull up the slide deck, just to give our viewers an idea of how we're going to discuss this topic, I am going to first focus on the California Consumer Privacy Act, only because everybody is very worried that it's coming into play as of 2020, and amendments are being adopted as recently as last week. There's still other amendments pending, and because it does seem to be the leader of the pack, if you will, in terms of the U.S. legislative landscape right now, I think it is worth spending some time talking about that particular piece of legislation. But also what we'll be talking about is the bigger picture and why the C-suite needs to care about this. Because until recently, this had been it's an IT issue. It's not, we don't have to worry about it. We're the board of directors, I'm the CEO, I'm the CFO, this isn't my problem. Well, if it's not your problem already, pieces of legislation, not to mention litigation, is going to make it your problem.
Right.
So rather than it becoming a problem, think about what TD Bank did when environmental mindfulness came into vogue and it was becoming popular to be green. TD Bank made this a marketing point. Their banks were rebranded with green stripes. Their branches had solar panels on them. They were the green bank. Now, I'm not suggesting that board of directors put out in their 10Ks or on their websites or anything else, we guarantee your security. And by the way, if you put that onto your website or in any public disclosures that we guarantee your security, I can tell you right now that's going to be an FTC violation because nobody can guarantee security. However, if you as a member of the board of directors and your company as a whole are taking reasonable measures, and of course the eye is in the beholder as to what is reasonable, to protect information. And again, remember, it's not just what's kept online, but what are paper files, what are disclosed, for example, in your 10Ks, what do you put onto your privacy policy as to what you're doing, all of those things, and by the way, what your vendors are doing with the data that you share with them. If you are taking reasonable measures and you are being proactive to protect that information, whether it's digital, in hard copy, or otherwise, you'll go a long way towards not only avoiding fines and litigation, but also being able to make this a marketing standpoint without a misrepresentation. So with that, I will call up the slide deck. Okay, so now that we've seen the lovely title, and of course my next slide is going to be my legal disclaimer, because of course you need to have a disclaimer if you're an attorney. So by all means, please read this and just know that until you retain me, and I hope you do, but prior to that time, this is not legal advice. I am not your counsel. This is informational only. So CCPA, or the California Consumer Privacy Act, it will be coming into effect in 2020. And then the question is, to whom or what businesses does it apply? It applies to for-profit businesses that are doing business in California that collect consumers' personal information and determine the means and the purposes for which that information is being processed. And you meet one of the following, not all, but any one of these. You have gross revenues in excess of $25 million. You buy, receive, sell, or share for commercial purposes personal information of more than 50,000 consumers, households, or devices, and or you derive more than 50% of your revenue from the sale of consumers' personal information. If you're not for a profit entity, this will not apply to you. If you're already subject to HIPAA or to Gramm-Leach-Bliley or the California equivalent statutes, you're not subject to the CCPA. But otherwise, if you are doing business in California and you meet one of these three benchmarks, not all, but any one, you need to be concerned about the CCPA. As far as what is a consumer, and by the way, this is, and I'll sidetrack every now and then to other jurisdictions' statute, it doesn't mean that I am a citizen of California. I don't have to own a house in California. I don't have to vote in California. It just means that I'm resident in California and not merely for a transitory purpose. So for example, if we're looking at GDPR, and a lot of people think it means that it applies only to citizens of England or citizens of France. That's not the case. GDPR applies to residents. So back in, and I'm aging myself here, 1989, my husband and I lived in Tokyo. If the GDPR, and in fact Japan has a similar statute, were in effect back then, because we were living in Tokyo for more than just a month, we would have been protected by the Japan equivalent of the CCPA or the GDPR. So keep that in mind when you're dealing with people who may not be full-time living in California, but let's suppose that you have a person who's stationed in California on assignment for a period of a month, 2 months, 3 months. Their data will come under this protection as well as somebody who's living there full-time. Now, a big question has been with regard to the CCPA as it applies to employees or doesn't. The most recent amendment adopted, AB 25, exempts information about employees or employee applicants at least until January 2021. Now, whether that exemption will extend further or not, that's yet to be seen. But it doesn't mean that you shouldn't start to worry about information about employees or applicants sooner rather than later, because guess what? I have a look back under the CCPA of 12 months. So consider this. I applied for a job with you in, say, December of 2020. Now, in March of 2021, I reach back to you under CCPA and I say, what did you have about me for the last 12 months? Assuming that this amendment stands, as of January 2021, I have the right to ask for that information as an employee applicant, and you need to tell me what you collected about me in the last 12 months. So even though this amendment may not be applicable immediately along with the rest of the legislation, you should already be tracking this data. Otherwise, it's going to be really hard to track those data points after the fact. As far as what is personal, in other words, what are you protecting, under CCPA, this is a very broad definition. And this is only a sampling of what's included in what is personal information or personally identifiable information. So it includes your name, your email address, your IP address, biometric data, an account number along with the access credentials, social security number, driver's license number, my consumer tendencies, not just my history, but my tendencies, my online activity, educational information, psychological trends, and the conclusions that you draw about me because of my online activity on your website. So think about this. One of our clients is involved in marketing, and they've got this wonderful database about their different customers. So let's assume that I was one of their customers. They might have in their contact information for Michell Schaap. Michell Schaap lives in New Jersey. She teaches snowboarding. She's got 2 kids. She loves dogs. She's addicted to cheesecake. And anything else that you can come up with about Michell Schaap that you would want to remember. Oh, and by the way, my birthday, of course, because you want to send me a birthday card as a good salesperson. All of that information is kept in this wonderful CRM system that this marketing firm has. Well, first of all, why do they need that information? I'll accept the fact that they use it for marketing purposes, but then consider this: who within their organization has access to that data? And when I asked that question to this particular client, the answer was, well, everybody. I said, okay, let's see if we can define everybody. Does that mean who's ever part of your sales team, who's managing Michell Schaap's account or pitching to Michell Schaap, or does that mean the person who answers the switchboard also? Needless to say, the answer was crickets, because they were saying, I guess the person who runs the switchboard can also, yeah, you like that response. And here's the problem. Years ago, you would say, oh, that's fabulous. This is a great marketing tool. That's wonderful. But with the advent of breach notification laws, and now laws like CCPA, which require proactive, reasonable measures to protect the data that you've collected, how was that CRM system created? How is the data in there tracked? Are they using third parties to manage the CRM system? And what if I, as an employee of the company, could take a thumb drive, pop it into my computer, download the whole system, and take it with me to my next employer? Needless to say, that would not constitute reasonable measures to protecting that information.
Right.
And yet, that's exactly what's happening with legacy data.
Yeah, that's a very good point. We see that so often when we're working on a pen test or a risk assessment, where we see improper configuration. A recent pen test where we have the client had a SharePoint server, and they had, say, floor plans or security project plans accessible to everyone on the SharePoint server. And we come in from the security side saying, all right, now let's think about separation of duties, who needs access to what. And CCPA and these regulations are sort of forcing organizations to start implementing these best practices that we as security professionals have been trying to get them to do for so long.
Well, and here's the interesting thing, and I'm sure you're seeing it from your side when you're doing this pen testing and risk assessment, is that many of the systems that were put into place several years ago, these legacy systems, were not implemented with privacy in mind.
Right.
They weren't
Right.
implemented with mapping the data.
Yep.
And now companies are scratching their heads saying, okay, how do I slap lipstick on a pig
Yeah.
to bring
Right.
my legacy systems compliant? Or do I have to throw out the baby with the bathwater and start over again? It's not an easy business decision. In terms of whether or not you're actually doing business in California, going back to CCPA, and this, by the way, is not under the CCPA, this is under different California statutes. The benchmark is, so let's suppose that I'm a new company, I'm actually formed in California, or I'm domiciled in California. That's an easy answer, then yes, I'm doing business in California. Or I have sales in California that exceed the lesser of $500,000 or 25% of the business's total sales. Or I have real and tangible personal property that exceeds the lesser of $50,000 or 25% of the total property. Or the compensation that I've paid in California is the lesser of $50,000 or 25% of total comp. And I want to stop on that last point because it's worth noting. A lot of companies may not be operating in California per se, but if you have even one employee in California
Right.
who's paid more than $50,000, you just put yourself into the category of doing business in California. It's a very broad-reaching statute. And you don't have to be located in California per se. You don't even have to be located in the United States.
So with that last point, the employee, well, what is the living span that they're considered a California resident? Is it 2 weeks?
I'm not sure if there's a clear benchmark under CCPA,
Gotcha.
and if you've seen something that says 2 weeks, please feel free to point me to it. What I've seen is language that says if your quote-unquote residency in California is more than transitory.
Right.
Right.
And that's why I look at an assignment, for example, of a month.
Right. So that's something to think about if you have remote employees who live, maybe they have vacation homes here, et cetera.
Well, I'm not sure if I would include vacation homes in that necessarily, because the employee now has chosen to go to a vacation home for a week's time, as opposed to think about how many consulting businesses will send employees to assignments
Right.
for a month-long period,
Right.
or a 2-month period, or a 4-month period. And that's not at all unusual, particularly if you're doing an audit.
Right.
True.
You know, and even if they're coming back on the weekends, so a lot of people who work for some of the big accounting firms, they'll be on an audit project for months at a time. And I think if I were the California AG, I would make the argument that that person was a California resident for purposes of CCPA, because in a 4-month span, they were only going back to their home state on weekends, and otherwise they were residing in California.
Right.
And again, if that employee's paid more than $50,000, guess what? Now you're doing business in California, and or you have information about a consumer in California, depending on which side of the equation you're looking at the data.
So I guess the short of this is this type of regulation is coming for everyone. So you might as well get on board and start structuring your systems correctly.
That's exactly right. There's a lot of different avenues how you can cross this and touch it. So you might as well.
Exactly. And by the way, even though I know that this summit is CCPA centric, New York just adopted the SHIELD Act,
Right.
which applies to businesses that have information about residents in New York. And New York, being as egocentric as it is, assumes that everybody has data about New York residents. Massachusetts has its own requirements with regard to Massachusetts residents. Maine recently adopted proactive legislation. My favorite piece of legislation is the one out of Florida, which has one sentence in its proactive legislation that currently says that you must adopt reasonable measures to protect information. Period. End of discussion. I'd love to know what that means. If somebody can point me to what is reasonable, I'd love to know.
Well, I don't know about what Florida, but in California, well, looking into that, some of the previous court cases there, we did find one court case where the judge said that following the CIS-20 security standards was reasonable security. So basically, organizations need to get on a standard framework and get organized.
Absolutely. And by the way, your reference to the CIS-20 is an important one for our viewers. Information about the CIS-20 controls, or what used to be referred to as the SANS controls, or to NIST, or to ISO. First of all, these frameworks and resources are free.
Right.
And I'll repeat that. Free. Available online. Shoot me an email, shoot the Bills an email. Either one of us can share with you online links to the CIS-20, to the SANS resources, to the NIST framework, to ISO. They're out there, they're available. And especially
and we'll be having a session on day 3 just talking about using frameworks also.
And that's one of our favorite topics is the CIS-20, as well as other frameworks, to keep pounding that in. And like you said, I really appreciate you reiterate it. It's free. It's free. You just have to implement it.
Exactly. So you can't use the argument, well, it's not in this year's budget, when granted, it has an operational cost, it has a time cost, but with no disrespect to my own practice or to the Bills business, and I hope you guys don't mind that I'm making you plural, but you like that, huh? But my point being that corporations don't have an excuse that it's not in the budget when these resources are available at no cost.
Right.
Now, I will tell you, and we're not getting into this discussion too much about actual policies and procedures, and certainly if you folks have questions about what policies and procedures should look like, please feel free to reach out to me by phone or by email. But I will tell you that SANS has online, and when I say SANS, it's S-A-N-S, all caps. All you need to do is research it. I will not use Google as a verb in case any Google attorneys are listening to this and they're part of their trademark police. Again, that's a different conversation. But when you print out the templates that are available online, remember they are templates, and it's not a one-size-fits-all. So let's suppose that one of the templates is for a password policy, and the template says that you have to change your password every 3 months. And I'm just throwing that out there as an example. Well, if you don't require employees to change their password more than every 6 months, and yet you put into your binder of written policies and procedures that SANS template without having changed it, that's going to be problematic when the regulators come in and say, show us your policies and procedures, and the written policies and procedures conflict with what you're actually doing operationally. Now, in terms of what CCPA does for consumers, and of course what it imposes upon businesses, or that is businesses that are subject to CCPA, and I'll just quickly go through these bullet points, but number one, if I'm a California consumer, that is a resident or a household of California, I have the right to ask you what you've collected about me in the last 12 months. I have the right to ask you to forget me or to delete my data, and there are certain exemptions or exclusions from that notion. I have the right to opt out from you selling my information, but note that if your business doesn't sell information, you have to specifically state on your website, we don't sell data. It requires you to not discriminate against me if I choose not to permit you to sell my data. And that means, for example, that I can't get discriminatory pricing if I'm not letting you sell my data. I can't not get the same products that somebody else allows you to sell their data. It does mean that you can give somebody who consents or does not elect to opt out, you can afford them incentives for letting you sell their data, but I can't have any less base benefits, if you will, if I choose to opt out for the sale of my data. Now, if I'm between the ages of 16 and 13, and of course one could argue, how do you verify that? But in either case, I must actively opt in, or better yet, have parental opt-in before you sell my data. And I have the right to request transfer of my data. So let's suppose that I've been a customer of yours for the last 5 years. I think you guys are awesome for 5 years, and then one morning I wake up and say, you know what, I don't like your brand anymore. I'm going to go to a different online brand or a different online resource. I have the right to tell you, okay, you're going to move my data from your website to this other website or to this new business rather than yours. You now need to comply with that request. And I also now have a private right of action. So if you haven't taken reasonable measures to protect my information, and as a result of your failure to take reasonable measures, I suffer a data breach, my information is compromised, it wasn't encrypted, and it wasn't de-identified, I can bring a lawsuit against you as an individual. We'll get into that further, but this is new because most breach notification statutes, and by the way, there are 50 different breach notification statutes for 50 different states and their own 50 different requirements, but now having a private right of action is new for California versus just the Attorney General's enforcement of those statutes. Keep in mind that when you are operating online, whether it's through your website, whether it's a mobile app or otherwise, you have to disclose what you're doing. And you need to make sure that those disclosures are up to date, complete, and clear and conspicuous. And you have an obligation now statutorily to review and update those policies annually. And again, you need to disclose what you're collecting, where you're collecting it from. I need to have the means to request my information, and it has to be two different means, a toll-free number or an email or a website. There are different requirements if you're only online, but if you're not only online, these apply to you. You have to indicate what information is being sold. And again, there has to be a clear and conspicuous link to opt out. You have to indicate when you're sharing information with third parties, and particularly if you're selling that information to third parties, or you have to state affirmatively that you're not. You also have to indicate what you're disclosing merely for a business purpose. Now keep in mind that you are allowed to do onward transfers. And when I say onward transfers, let's suppose that your business is being sold in a merger or an acquisition, provided that you state in your policy that you may be in fact transferring data in such a transaction. However, let's assume that you're covered under the CCPA and you've been compliant with the CCPA, but you're now acquired by a business that's located in Minnesota. And Minnesota and the entity that's just acquired you was not subject to CCPA, and Minnesota didn't have its own equivalent of CCPA. Now, having acquired your business, the Minnesota-based business is now going to have to worry about CCPA and get all of its internal systems up to speed quickly. In terms of what will happen if you don't comply with CCPA, again, we still have the Attorney General enforcing these laws, and it's $2,500 per violation for an unintentional breach, and $7,500 for an intentional act. I'll get into a case later which discuss what is an intentional act, and again, board of directors need to be aware of what would be an intentional act for purposes of this. But you say to yourself, $7,500, it's not horrible. Well, except for the fact it's per violation. So let's suppose that you have numerous records about Michell Schaap, consumer in California. And now you have numerous records about the bills. And you have numerous records about all of your customers. Now multiply that $7,500 number by that number of consumers in California. And that 7,500 number suddenly has a lot of zeros after it. Now, I'm sorry, go ahead.
No, it's,
No, I
Bill,
wasn't
were
saying
you going to
anything.
say?
you said right. That's exactly right.
The other thing is that as far as if it's an unintentional violation, you may or may not get the luxury of notice in advance, and you do have a 30-day cure period. However, depending upon what the nature of your breach is, you may or may not be able to cure it within 30 days. So better to be proactive than reactive. And again, in terms of a consumer's private cause of action, again, $100 to $750, and you think that's not a big number until you multiply that out in a class action. And if you think California is not ripe for class action litigation, then you haven't been reading the press. California is one of the most litigious states in this area. And other attorney generals are jumping on board, and so you see multi-district class action litigation with regard to data breaches. And the C-suite has to be paying attention to this potential liability, or they're not fulfilling their obligations to their shareholders, let alone their customers. You will not be liable, and again, we talked about what is reasonable, if you've taken reasonable measures to protect the data that you control, and if the data that has been accessed is encrypted and or de-identified, you will not be held accountable for a data breach under the California statute or the other 49 states breach notification laws, provided that the the decryption key has not also been compromised. Decryption key with the encrypted data, not much of a protection and not much of a reasonable security measure either. Now, I will add a footnote to this, and it's interesting. New York's SHIELD Act recently amended the New York breach notification statute to say it used to be that it was the acquisition of personally identifiable information. Now it's the mere access. So let's suppose that I am an employee of a company and I work switchboard and reception. I'm not part of the HR organization, and I get access to HR data. That mere act of me as an employee having access could potentially be a breach under the SHIELD Act, depending on why I was accessing that information. Now, the flip side of that is, let's suppose that Bill and I work together. And in fact, this is perfect because we have two Bills. And my email auto-populates. And I intend to send an email to my coworker, Bill Price, about an employee who's going to be let go. And Bill and I are both part of the HR organization. But Bill, too, is in accounting and has nothing to do with the HR function. And when I send my email to the correct Bill, my email auto-populates to the other Bill. Provided that, number one, that was unintentional on my part, and number two, we quickly realize, oh, gee, that shouldn't have gone to Bill 2. We notified Bill 2. He deletes it from his email. That will not be an unauthorized access that requires breach notification. However, all of the steps that I just talked about, that is documenting what happens, making sure it's deleted and what have you, has to be recorded and retained for 5 years.
So it's kind of the way that
Not a
HIPAA
simple
has
process.
approached this all along, right?
Correct. And by the way, as I mentioned on one of our earlier slides, if you're already in compliance with HIPAA or Gramm-Leach-Bliley, you're not worrying about CCPA because hopefully you've already been worrying about the obligations under HIPAA.
But it's sort of that same approach and thought process around privacy and access. It's not
Correct.
just the hackers or the attackers getting access. Your employees could
inadvertently
get access when they're not supposed to.
Absolutely. And again, the inadvertent or mistaken sending of information to an employee, provided that you document it and you make the reasonable conclusion that it was appropriately deleted from that employee's computer and what have you, that's great. It gets a little bit trickier though. So let's suppose that in the example I gave, Bill 2 accessed the email on his home computer, not on a work computer. Now I need to document that Bill deleted that from his home computer. Or if he opened the email on his cell phone or on his tablet, have I accounted for all of those data points when I'm documenting that yes, in fact, it was deleted? So this is not for the faint of heart, and the logs need to be that detailed so that I can say that I took reasonable measures to make sure that that inadvertent disclosure didn't become a breach.
Right.
Now, in terms of board of directors being part of this discussion, we're going to go back to 1996, and everybody's saying, why am I worrying about 1996? Well, courtesy of the Delaware Chancery Court's decision in the Caremark piece of litigation, they found that directors can be held personally liable for failing to appropriately monitor and supervise the enterprise, and that the board of directors has to have records with regard to those systems that are monitoring the enterprise. And if they fail to have those records, and had they had the records, they could have avoided the breach or the compromise, then they will be held as board of directors members liable. That's the door that opened for board of directors going back in 1996. And I will tell you the Caremark case is being cited again and again and again, and it's still good law. And it's being cited this year in investor and shareholder litigation where board of directors have not monitored the enterprise, don't have reporting systems, and are not looking at the reports that are being sent to them. How these pieces of litigation are manifesting themselves, and again, all you need to do is read the headlines. It's in shareholder litigation. It's in consumer litigation. You're seeing it in insider trading litigation, and of course, the impact that it's having on mergers. And without getting too deep into the weeds here, because again, you can read any headline you want to about any one of the breaches I've noted here, but Equifax had so many issues coming up with that. And for those of you that are not familiar with the history of the Equifax breach, Equifax knew in March of the year that this all happened, which was in, I'm forgetting my history now, is it 2019 or 2018 at this point?
2017,
Seems like ancient
I believe.
history. And again, there's been so many breaches since then, it's hard to keep up.
Right.
But in March of that year, Equifax knew it had issues with its system. It knew it had a vulnerability, and it had hired a consultant to help them shore up those holes in their system. The problem is they then got into a fight with the consultant, and they fired the consultant. But in the meantime, the back door was still open, and they didn't bring on a new consultant to complete the process. Then the compromise happens, and we realize how many hundreds of thousands of millions of records were compromised by Equifax. And members of the C-suite saw the writing on the wall and short sold the stock. So not only did you have a breach, you had a known vulnerability, you didn't take reasonable measures to complete the process to close that back door, but you were self-dealing to put money in your own pocket before the stock tumbled. Oh, and then the postscript was that in October, after the breach, when the then acting CEO went before Congress to testify and they were asked Is the data now protected? Is it now encrypted? And the answer was, I don't know. That's a really bad message to the consumer public, to your investors, to your shareholders, to the regulators. I don't know is not a good message from your board of directors. Now, when you think about Yahoo and Marriott, they were two breaches that impacted the companies after or before a merger, depending upon how it happened. So with Yahoo, remember that we had this massive data breach, which initially was not disclosed at all. And I firmly believe that had Yahoo not been in the process of selling itself to Verizon, Yahoo still would not have necessarily disclosed it to the public. However, because they knew Verizon was going to discover it in the course of their due diligence, they finally came clean and went public with the breach. As a result, Verizon cut the purchase price by over $300 million. That's not a little haircut. And if you were expecting to get a lot of money out of that sale as a shareholder, now you're not going to be happy, number one, because there was a data breach. Number two, because it wasn't disclosed. Oh, and by the way, number three, your stock value just went down. Not good. With Marriott, the problem with Marriott was not that Marriott had a breach, although subsequently it did, but it was the Starwood breach. With the Starwood breach, that breach occurred pre-merger. However, it was not discovered in due diligence. And for any of you who are involved in mergers and acquisitions, you know that there's various reps and warranties that are given in a merger document, which says that we represent warrant, that we've done all of these wonderful things, and to our knowledge, there's nothing else out there. And if any of these representations and warranties prove to be untrue or materially misleading, we will be liable to you. However, in mergers and acquisition agreements, if they're appropriately documented by the attorneys who've negotiated them, there's a limit as to how long that indemnification obligation stays in place. The Starwood breach was not discovered until several years after the merger closed, and so Marriott didn't have the ability to look back at Starwood, didn't have the ability to look back at Starwood's own insurance that was in place at the time the breach actually occurred, and Marriott was left holding the proverbial bag. If litigation is not enough to scare you away as the C-suite member, if loss of your stock value is not enough, if having to testify before Congress and saying humana, I don't know, is not enough, now you've got statutes that are requiring you as a member of the C-suite to have affirmative reporting obligations. And again, this goes back to the Caremark decision in 1996, but it's now being codified, for example, in New York State's Division of Financial Services Regulations, which specifically says senior management must take this issue seriously and be responsible for the organization's cybersecurity program. And the regulation requires that written policies be approved by a senior officer or the covered entity's board of directors. So now you've got with this specific New York regulation that applies to the financial industry and to insurance companies that the board of directors and senior management be involved in the process. Also, if you're a publicly traded entity, you've got the SEC making clear as of 2018 that companies should be disclosing how the board addresses oversight of cybersecurity. So again, board of directors, you can't say you didn't know, and you can't say it wasn't in this year's budget anymore. The SEC reporting obligations, and I've shared with you the link here, specifically state what in fact companies have to do. They have to establish and maintain appropriate or reasonable, effective disclosure controls and procedures to accurately and timely disclose security events. So now we're not just talking about having proactive policies and procedures, which is, for example, what the New York State regulation requires, but if you have a data breach, you have to accurately and timely disclose that data breach. This is on top of the 50 different states' breach notification regulations. So if you're a publicly traded entity, you have a lot to think about here. Again, this is just more of what's required for publicly traded entities. I'm not going to read every slide to you because, frankly, I don't want to put you to sleep, and you can read the slides by yourself. The short answer is, if you're in the C-suite and you're a publicly traded entity, if you're not being proactive and you're not making sure that whatever the business is doing is not documented, you can and will be held accountable individually as well as corporately. Now, a lot of companies are in states still that don't have a CCPA type statute or the New York Financial Regs or the SHIELD Act or the laws that were adopted in Nevada or in Colorado with regard to investment advisors or what have you. However, and I alluded to this earlier, in Pennsylvania, the Supreme Court found that there was a common law duty for businesses to exercise reasonable care to prevent against reasonable and foreseeable risks. And in that particular case, and I'll just give you my own version of the events. So let's assume that it's Friday afternoon and I work in the HR organization and it's 4:45 and I've got one foot out the door to go to happy hour. And I get an email from my boss, who's the head of HR, that says, we're having a Department of Labor audit on Monday. I need you to send to me all the employee files. Happy hour's calling. My friends are saying, where are you? I want to be a good worker bee. I hit send, the file goes, and I go off to drink. Now I come back to work on Monday, and I say to my boss, so when is the audit? And my boss looks at me and says, what audit? And now I'm realizing, oh dear. And I'm sure the expletive was something more than oh dear, but I'll be polite. What the court found here was that because phishing exploits, like the one I just described, are not just foreseeable, but by the way, the IRS put out an alert about that specific type of phishing attack in 2015. SHRM, the Society of Human Resources Professionals, put out its own alert in 2016. And because the company didn't train its personnel to be aware of those types of phishing attacks and to know, we talk about what's reasonable, to simply pick up the phone. I don't care that it's 4:45 on a Friday. I don't care that it's 4:45 on Labor Day weekend. If you get an email like that, pick up the phone and verify.
Right.
And this employee hadn't been trained to do that simple, no-cost step or was simply too lazy to do it. And the court found that under common law, the company acted unreasonably and exposed the employee's data to the foreseeable risk of hackers.
There was a case similar to that in North Carolina where we are just last year.
Yep.
It's slightly different. Oh, there you go.
Yep.
Well,
exactly. And that's the point. It's not just Pennsylvania. And it's not just North Carolina. And by the way, in North Carolina, it was a federal court, and they found that the company was intentionally and essentially complicit in the breach because it hadn't trained its personnel. I mean, think about that. The company was potentially exposed to treble damages because it hadn't taken the time to train personnel to pick up the phone and to verify a request. We're not talking about big dollars and cents here, guys. We're talking about a 1-hour lunch and learn with your personnel to bring them up to speed, to have a written policy and procedures, and this company couldn't be bothered.
And don't use the phone number that is in the email address. Use the one that you know for them.
Well, and you say that. So just recently, my business, again, is primarily based in New Jersey, and obviously I have relationships with attorneys at a number of different firms in New Jersey. I got an email from a partner in another firm in New Jersey. I didn't know this particular partner, however, I know several partners in the firm, and the email said, please consider this proposal and call me. Now, I'm paid to be paranoid. So what do? I don't respond to that email. I don't call the number in that email. I instead go onto the internet. I look up the known email address for this attorney and the known phone number. I email the attorney and I say, hi, did you send me a proposal? Thanks, and just kept it that simple. And I also called the known phone number and left a message for the partner saying, I got this strange email from you. To my knowledge, we're not doing business together. Please give me a shout. I got an email responding to my email. My email was in the string of responses that said, yes, it's a proposal. Please take a look at it and give me a call. And now, if I weren't that paranoid, I would have clicked on the link because I've emailed the known address. I've gotten a response that cites my email sent to the known address. But because I am that paranoid, I still didn't click on the link because I knew I hadn't been dealing with this guy. There's no reason he would have sent me a proposal unsolicited. And I waited for the phone call back. And sure enough, that afternoon, the partner called me back and said, "Thank God you called me. Thank you so much for alerting me." And what happened, in fact, was that somebody had compromised their email system and set a rule to redirect emails internally. So simply looking up the known email address for this particular partner would not have protected me from clicking on this phishing link.
Right. That's why we always recommend a completely sort of like multi-factor authentication, something completely out of band of that type of communication to verify.
Exactly.
Like what you did with the phone number.
Exactly. And again, you think about the time involved for me to have done that. If the proposal was that critical, the odds are good he would have picked up the phone and called me in the first instance and said, "By the way, Michelle, I'm sending this to you now. You got to look at it."
Right.
Instead, and instead I just got that unsolicited email. And sadly, although I'm alert enough and I'm trained, and obviously this is what I do, so I did not click on the link. I did take those extra steps. There are several other firms in New Jersey where attorneys were not that proactive, were not that well trained, and they did in fact click on the link and then released that breach into their own systems and then had to do triage for their own systems.
Right. And that goes right back to, what you were saying earlier, is it's just training. And again, that's one of the things that we talk about a lot is just training. Had you not been trained, you would have clicked on that. And it just was training your people. And that training could alleviate a huge breach, which you just outlined.
Exactly. And the cost of training, the C-suite is always saying, it's not in this year's budget, we don't have time. Do you have time to be out of business? It's that simple.
Right.
Do you have time to be on the front page of the Wall Street Journal? And if the answer is no, then you've got to invest in risk management. You've got to invest in technology. You've got to participate in training. And you have to instill a culture of privacy, data protection, and cyber mindfulness.
And now with CCPA fines and the other regulations, we have actual numbers we can look at to compare. All right, this is how much a breach could cost me. So now for the C-suite, like say the security team to take to them and say, all right, this is the cost of training and this is the cost of breach. And now they can make a choice.
Well, and again, without endorsing one particular report or another, the Ponemon Institute comes out with a report every single year after analyzing reporting from hundreds of companies around the world. And by the way, if you look at the Ponemon Institute report, it actually breaks it down by United States versus other countries. It breaks it down by, for example, the healthcare industry versus the retail industry versus hotel industry, what have you, in terms of what a data breach costs. And they explain what the dollars and cents are. So, for example, if a health record is compromised, one single health record, I believe the going rate for recovering from a data breach of that one record is upwards of $450, possibly a little bit more. Whereas a credit card breach, because credit cards are so ubiquitous at this point and it's easy to cancel a credit card, I believe the value of a credit card is somewhere between 150 and 200 these days. Don't quote me on those actual numbers. Look at the Ponemon Institute report, look at the Cisco report, Verizon issues a report. But to your point, Bill, you can quantify what's out there in terms of the potential exposure. And by the way, not only do you have a dollars and expense exposure, you've got damage to your reputation, and good luck getting that back.
Right.
You've got operational impact. So how many of your employees that should be doing their normal function are now busy scrambling to respond to an incident or a breach? And how many people are doing their jobs versus copying their resume because they think you're not going to be in business next year and they want to look for their next job?
Right.
Exactly. I mean, that's really what we're looking at. If the C-suite is not setting this tone, and if they're just leaving it to IT, nobody else in the business is going to buy into the process either.
Right.
And the time is over for the C-suite to put their heads in the sand. So in summary, whether it's the CCPA, whether it's consumer statutes, whether it's common law, the duty is there. Whether you like it or not, it's here today. The participation from the C-suite is essential. And if you're not educated, if you're not prepared, not only is your job on the line, but by the way, if you're a stockholder, enlightened self-interest, you're going to lose your own livelihood and your own net worth. So if you're not motivated by a corporate responsibility, be motivated by your own pocketbook and be prepared. Guys, further thoughts, questions, comments?
Well, I think you've covered it pretty well. I will add one thought about CCPA, not CCPA, what C-suite buy-in. So often, that's from a security side, that's what we push, is to get your higher levels to buy into the program and to set the example. Because when they set the example that it's important to them, it trickles down the ranks to everyone else. And it helps create that culture of security, privacy-minded in your organization.
That's right. That's right.
Exactly. And with that, gentlemen, I will thank you again for the opportunity to speak to your audience. Folks, if you have questions, if you have concerns, need more information, want access to the resources for NIST, for SANS, for the CIS-20 controls, ISO, more than happy to send you those links. I will tell you, if you're in New Jersey, if you're not a member of the NJ-KIC, you should be, because they push out regular alerts. The IC3 through the FBI puts out regular alerts, and you can get this information for free. So please avail yourself of it and stay in business.
And we'll provide a link to your website right under the video. How else, if they want to reach out to you, can they do that? What's your preferences?
More than happy to respond to phone calls, emails. This last slide shares my contact information, and also you can find me on the website. And you don't even have to be able to spell Chiesa, Shahini, and John Tomasi.
Well, thank you very much for your time today. We really appreciate it. It was very informative.
Very informative. A lot of good information.
My pleasure, guys, and I hope the rest of the summit is fabulous.